Hello everyone, welcome to Legal Darshan. In today's video, we are going to talk about marriages in Hindu law. Okay, so before we proceed further, there are two views on the marriage. One is the ancient, that is pre 1955 Act. 1955 Act is the Hindu Marriage Act, and one is after the enactment of Hindu Marriage Act. Hindu Marriage Act 1955. So before the Hindu Marriage Act was implemented, there was a lot of discussion that was going on within the Hindu Code Committee. So there was this B.N. Rao Committee, which was constituted for reforms in Hindu law. All right. And one of its members were Dr. Bhimrao Ambedkar, who was pioneer in bringing the reforms in Hindu marriage system. Now, when we talk about marriages in Hindu law, in ancient times there were 8 kind of marriages. Okay, so we had 8 kinds of marriages like Brahma Vivah, we have Dev Vivah, we have Daitya Vivah, we had Gandharva Vivah, Prajapatya Vivah, and all that. Okay, so there were good and bad kind of marriages in which some forms were considered good, some were considered bad. So the forms, those which were considered good, included Brahma Viva, which was essentially a ceremony between the Brahmin groups of the society. Dev Viva, in which a father basically gives his daughter as Guru Dakshina to the priest for performing some pious ceremonies or havans at his home. And there was Prajapatya Vivaha also, which was considered to be a good form of marriage. One of the things that we have to note is that one of the Vivaha was Gandharva Vivaha. So now your Hindu Marriage Act is based on the concept of Gandharva Vivaha, in which consent of both the parties is important. Consent of bridegroom as well as consent of the bride if they are in the age of majority. So now this which earlier was considered a bad form of marriage in pre-1955 era became the basis, the sole basis of formulating the Hindu marriage code, that there must be consent present of both bridegroom and bride if they are in the legal capacity to give the consent. Legal capacity here means that they are major over the age of marriage, and also they are in the sane mind. They should not be in the state of unsound mind. If any of the legal incapacity is happening, that is, they are not sane, that is, the mind is unsound, or they are minor, then also the consent of guardian is important of both the parties to the marriage. Now, one of the features of ancient marriage, ancient Hindu marriages, is that in ancient Hindu marriage was considered to be a sacrament. It is still considered as a sacrament, but now we have a little bit addition of contractual flavor as well. Now, in ancient times, marriage used to be sacrament. It was known as eternal union of two people, indivisible bond, that which means if two people marry, the bond cannot be dissolved. We all have heard the concept of Saat Janmo ke Jeevan Saathi and everything. So these particular concept, these particular notions arose out of this concept only. Now, when we are talking of eternal union or indivisible bond, it is important to note that Manu Smriti, which guided Hindu marriage for a large number of years, it did not permitted divorce. Manu Smriti did not permit divorce. Rather, divorce as a feature in now Hindu Marriage Act is taken from the Narad Smriti. So Narad Smriti is one of the Hindu Smritis that have mentioned that yes, divorce in a marriage is possible under Hindu religion. Now, see, the problem here arose was that once you marry a person, we know of the evils like Sati Pratha, widow non-remarriage, which were later eliminated by a lot of social activists. So now with these features like the marriage being sacrament, marriage being an eternal union, marriage being indivisible bond, there were things like sati, there were things like widow non-remarriage going on, and ultimately women were being subjected to all these things because these all of these things were ultimately made for women. We have never seen a man being sati for his wife or not remarrying. So all these were basically gender biased, and therefore Hindu code was one of the steps to eradicate all these stigmatizing activities. Now, earlier, the marriage was, as I was telling you, it was purely a sacrament. After enactment of Hindu Marriage Act, what changed was that there was a provision of divorce. There is a provision. Now, the flavor of Hindu marriages is not purely sacramental, but sacramental with a blend of contractual also. Because in contract, why is contractual? Because in contract we have the capacity to come out of it. That is why contractual, not that two people are contracting to marry each other. So when we introduce the contractual flavor, just how the contract works. Now your contract is, when we talk about contract, it is either void, it is either valid, or it is either voidable. Now, a similar feature was adopted in the Hindu Marriages Act. Before Hindu Marriage Act, we had no concept of voidable marriage, void marriage, or divorce. But after Hindu Marriage Act came into picture, the law formulated the conditions where a marriage could be void, where it could be valid, and where it could be voidable. All right. Now, when we speak of what are these conditions of void, valid, and voidable, we are going to look at some specific sections. Now, this video, it will give you a clear idea of the few sections because in this video, we are going to discuss the kinds of marriages and how do we categorize one marriage as a void marriage, valid marriage, or a voidable marriage. Now, in this video, we will cover section 5, section 7, section 11, section 17, and section 18 of the Hindu Marriages Act. So your 5 sections will be covered in this video. All right. We will touch a little bit upon section 12 also. Now, when we talk about how do we characterize what marriage is a valid, what marriage is not valid, we first need to look at section 5 and section 7 of the Hindu Marriage Act. If your section 5 and section 7 of Hindu Marriage Act is accomplished, it is without any anomaly or without any doubt, it is fulfilled, the criteria is fulfilled, then a marriage is deemed valid. Or not deemed valid, marriage is valid. But if there is any contravention, if there is any contravention at any point mentioned in this section, the marriage could either be void or the marriage could either be voidable. All right. Now let's quickly discuss section 5, which is the heart and soul of Hindu Marriage Act, because it ultimately lays down the parameter for a Hindu marriage. Okay. Yes. So in Hindu marriage, section 5, sorry for the gap, there was some technicality issues here. Now section 5 says conditions for a Hindu marriage. The title of section 5 reads Conditions for a Hindu marriage. It's good if you are having your Bare Act handy with you, but even if you are not having, a kind attention to this video will clear all your concepts relating to these particular sections. Now, conditions for Hindu marriage, it includes a marriage may be solemnized between any two Hindus. The first thing that we need to notice, any two Hindus, which in your section 5. So this particular act will only be applying to Hindus, as also discussed in section 2 of the act. So Hindus include Hindus, your Sikhs, Jains, and Buddhists. Okay. Now, for Hindu, there is a negative definition that anybody who is not a Muslim, Jews, Christian, or Parsi can be deemed as a Hindu. So anyway, the the concept that we are discussing today is conditions. Now, the first condition is no spouse living at the time of marriage. So section 5, clause 1 speaks, Roman 1 speaks, that there should be no spouse living at the time of marriage, which ultimately stops you from activities like bigamy, marrying two women, polygamy, marrying more than two women, polyandry. Polyandry means marrying more than one man, and biandry, marrying two men, etc. Okay. So these are the activities which are stopped by way of this section, this particular subsection. So basically, if you have a spouse living at the time you are marrying somebody else, then that marriage would be void. We will discuss the consequences. First, we are going to discuss the conditions. Okay. Yes. Now, your second condition is now the second condition of a valid Hindu marriage is that at the time of marriage, neither party is incapable of giving a valid consent. Incapable of giving valid consent. यानी कि दोनों पार्टीज जो हैं उनका मेंटल सिचुएशन साउंडनेस ऑफ माइंड इस तरह होना चाहिए दैट अ वैलिड कंसेंट कैन बी रेंडर्ड. अब इसमें थ्री कंडीशंस हैं कि या तो अनसाउंड माइंड की वजह से वो इनकेपेबल हो. सेकेंड कंडीशन है, फर्स्ट कंडीशन इज अनसाउंड माइंड, देयर इज एन इनकेपेबिलिटी. सेकेंड कंडीशन इज दैट they have a mental disorder making them unfit for marriage or unfit for procreation. And third condition is recurrent attacks of insanity. तो अगर ये तीन conditions हैं, then in that case the marriage done might not be a valid marriage. Okay, so basically you are able to give your consent for the marriage is the essence of this particular clause subsection. Okay. Now third is the age of marriage. So according to this section, the bride and the groom, the bride must be 18 years old or more, and the groom, he must be 21 plus years. Okay, not younger than 18 or 21 years respectively for bride and groom is the age prescribed as a condition of marriage under Hindu Marriage Act. So these all are five conditions which I'm going to list. All of these five conditions are the conditions in which, if fulfilled, the marriage is a valid marriage. Now, fourth says no sapinda relationship. Sorry, fourth is no prohibited relationships. सेक्शन इसको हम रीड करेंगे सेक्शन 3 के साथ जिसमें प्रोहिबिटेड रिलेशनशिप्स डिफाइंड हैं. So your prohibited relationships include your mother, your brother's wife, your grandfather's wife, or any such relations which have been mentioned in section 3. Now subsection 5, which says no sapinda marriage. The marriage will not happen in your sapinda. What is sapinda? Sapinda is that a person X is married, so that person cannot marry within the same linear ascent for 3 generations from mother's side and 5 generations from father's side. This is your sapinda. So basically, if anybody is having same ascent, line of ascent within these limits, then that marriage will also be void. So you cannot marry somebody, a person who is the daughter of your mother's brother. You cannot marry a person who is the daughter or who is the son of your grandfather's brother's child also. Okay, because we are covering 5 generations with father. Now, this is that if all these criteria for a marriage is fulfilled, then the marriage is a valid marriage. These are the conditions. Now, conditions are fulfilled, but what about how marriage is happening? Solemnization. So once your section 5 is fulfilled, we move to check whether section 7 was fulfilled or not. Okay. Now in section 7, what happens is section 7 says about solemnization of marriage. Section 7 bolta hai that marriage must be solemnized in the manner, your marriage must be solemnized in the manner as per the customary rites and rituals of any one of the parties to marriage. Customary rites and rituals. एक party के भी हो तो चलेगा. For any one party. For example, a Hindu girl marries a Sikh man, then in that case, even if they are fulfilling the customs of a Sikh marriage, that is a valid solemnization under section 7. If there is no rites and ceremony, all right, and if there are rites and ceremonies, and those rites and ceremonies include Saptapadi as a practice to performed, then that marriage will not be solemnized without doing Saptapadi. Saptapadi is taking 7 steps before the holy fire. So these 2 things have to be satisfied in order to be it a valid marriage. Now, what happens if section 5 or section 7 is violated? Any one condition is violated, or if fulfilled, one condition is fulfilled, one is violated, what happens? Now, if your section 5 is fulfilled, but section 7 is not fulfilled, and use different color, section 5 is fulfilled, but section 7 is not fulfilled, then your marriage is going to be a void marriage. Because if you are not performing your rites and ceremonies as per what is demanded by your own customary practices, then it is not a valid marriage. So anytime when there is a breach of section 7, the marriage will be void. All right. Now let's come to section 5. So we will understand it by one chart. Now your section 5, it gives you 5 conditions. One is we can take it as no spouse living. This is your clause 1. Clause 2 is capacity to consent. Clause 3 is age 18, 21 for male, female 18, 21 male. Okay. Then we have prohibited, that the marriage must not be in prohibited relationship and marriage must not be in sapinda relationships. there is one exception to the prohibition rule. अगर दोनों parties, if the custom of both the parties allow, if the custom of both the parties allow, that we can do prohibited marriage and we can do sapinda marriage, then in that case it is a valid marriage. Okay, then it is permissible. But what happens when it is not allowed? That we are going to just see next. Now, just remember this one chart and section 5, section 7, section 11, 17 and 18 will be clear to you. So when there is no spouse, when there is a breach of this condition, जब आप इस condition को breach करोगे तो you are doing either bigamy or polygamy or polyandry. Then in that case, the marriage, the bigamous marriage, polygamous marriage or polyandrous marriage, that is void. Void भी है under section 11. Section 11 बोलता है कि ये marriage void है, चाहे आपने section 7 को follow किया हो. And it is also punishable as per section 17 and 18 of Hindu Marriage Act. Section 17 of Hindu Marriage Act, sorry. Okay. So this marriage is a void marriage and also a punishable marriage. Okay. Yes. Now, coming on to the second condition, अगर second condition का breach होता है, capacity to consent, यानी कि आपके consent के बिना आपकी शादी हुई है, then in that case, the marriage is voidable and you will refer to section 12. No punishment. Now, when you have the age thing, the marriage happens in minor, or either one of the party is minor or one of the parties major to it, then in that case, the marriage according to Hindu Marriage Act is neither void nor voidable and therefore valid, but punishable. So section 18 provides for its punishment. But there is a twist here. We also refer to the Child Marriage Act, which says that the marriage of minor is voidable. So when anybody asks you what is the nature of marriage of two people who are not on the age of majority as per Hindu law, then there are two stances. Hindu marriage makes it permissible, valid but punishable, and Child Marriages Act makes it voidable plus punishable as well. So there are two stances. Now, this particular concept I will also discuss in one of more videos on this series, and then we can look into it. Now, when there is a marriage between a prohibited relationship or sapinda relationship, the marriage is void. Section 11 says so. Then your marriage is void and it is also punishable under section 18. So your section 18 makes it punishable that if two people are marrying within sapinda or within prohibited degrees, then in that case, there can be an imprisonment up to 1 month and there can be imposition of fine up to ₹1,000, or it may be both. So these are the stances which are taken by the Hindu Marriage Act. I hope this one particular chart is clear to you. And if this will help you in remembering sections 5, 7, 11, 17 and 18 of the Hindu Marriages Act. So in our next video, we will talk about voidable marriage. We will talk about the child marriages as well. Now, to summarize it quickly, I'll make again a table. So when section 5 clause 1 is contravened, we have void marriage under section 11 and it is punishable under section 17 according to section 494, 495 of IPC or the new sections which are there in now BNS. When section 5 clause 2 is contravened, the marriages are voidable as per section 12. Section 5 clause 3 is contravened. The marriage is valid but punishable under Hindu Marriage Act section 18, but voidable under Child Marriages Act, Protection of Child Marriages Act. Then Section 5, Clause 4 and Section 5, Clause 5 says that subpenda and prohibited marriages are void plus punishable. So void is provided in Section 11. Punishable punishment is provided in Section 18. But in the case when customs of both the parties allow the marriages between subpenda and prohibited degrees, then in that case the marriage is not void. This is the whole concept of when a Hindu marriage is void, valid, or voidable. I hope this video was helpful for you. For any more doubts in family law or any other subject, you may leave and drop down a feedback at the email address given here, which is legaldarshan@gmail.com. You can also leave your feedbacks or any comments in the comment box below. Thank you, everyone. Have a great day.